Ms. Doherty, do I understand that you're going first? That's what my little... Okay, thank you. Good morning.
Good morning. May it please the Court, Elizabeth Doherty for the appellee in the appeals court, Robert Pina. With me, Doug Darnbrough, who was the trial counsel in this case. This case, as has already been addressed in the preceding case, this also addresses the quantum of evidence necessary to establish a nexus between the items sought and the place to be searched. I would submit that in this case, it falls far below the necessary facts set forth in the affidavit. As in Medina, the affidavit in this case contains very little to establish a nexus. Insufficient facts, certainly falling far below a substantial basis to establish the nexus.
What you do have in this case, and you can correct me if I'm not getting all the details right, but there is considerably more opinion by the affiant about this is the way drug delivery services are operated, in my opinion, after all my training and experience. So you've got something that puts a context around it that is not in the affidavit, I would suggest, in the first case.
That is true. There is a statement from the detectives, I believe it's Safiolis. I would submit, in looking at it, it really is more in the line of, sort of generalizations.
Conclusory statements?
Excuse me?
Conclusory
statements really doesn't rise to the level of sort of an expert opinion. But even assuming that perhaps it did, it's fairly clear that you can't use, without an evidentiary basis to establish a nexus, you can't prop up the deficiencies in the affidavit just by including an expert opinion. I'd contrast it, as I do in the brief, to this court's case in Commonwealth versus Anthony, where this court did find that an expert opinion of the detective, which I would suggest in that case truly did rise to the level of an expert opinion. In that case, the affidavit from the facts of the case contained far more facts to establish a nexus.
Did this affidavit indicate prior purchases?
While I was waiting for this case to be called, I went and looked at the affidavit, which is included in the back of the Commonwealth's brief, and the exact wording is, the informant has purchased and continues to purchase. It does not specify how many times the informant had purchased. I would suggest that rises to perhaps once.
But even if it is multiple occasions, is there anything in the affidavit, or in the information, I should say, is there anything provided by the confidential informant? It's contained in the affidavit that indicates that on the knowledge of the confidential informant, the sales that the confidential informant was involved in originated from the defendant's house.
No, there's not, Your Honor. There's, as in some other cases, for instance, in Commonwealth versus Hardy appeals court case, Commonwealth versus Blake, a Supreme Judicial Court case, those are cases where the informant has been told by the defendant that they stored drugs in their house, or that they were able to get a certain quantity of drugs that they were on hand. I believe that's from Commonwealth versus Blake. No, there is nothing in this affidavit up to this informant's knowledge that drugs are stored in this house. Nothing whatsoever. There is as in Medina, there is nothing whatsoever in this affidavit as to how many times has bought. Unlike Commonwealth versus Luthi, there's nothing in this affidavit which suggests that this informant knew that the defendant sold to anyone else. For all that we know, the informant could have been the only person who purchased from this defendant. There's nothing to indicate there. Also, very significant, there is nothing as to...
both you and the prior lawyer make that argument that, for all we know, this is the only person that the defendant is selling to. Why does that matter?
Well, it matters, in the prior cases, amount and the amount of drugs are very significant as to setting forth facts which support an inference that drugs would have to be stored in the house.
As opposed to the car.
As opposed to the car or somewhere else.
But even if he only sold, even if the defendant only sold to this one confidential informant, the informant did say that he has and continues to buy cocaine from this man. And so the storage place has to be somewhere.
The storage place indeed has to be somewhere, but the case law from this jurisdiction has been that there have to be some facts in the affidavit to create a nexus. Otherwise,
Well, I agree with you, but I'm asking you why both of you are arguing that there have to be other buyers. The offense is selling cocaine, and it's an offense to do it even once. So I don't understand why you keep emphasizing the
Well-
lack of evidence of other buyers.
well, again, just looking at previous cases and factors that previous cases have considered.
You mean you're saying if large amounts of cocaine are stored, then it's more likely that it's in their house? I don't necessarily follow that. But.
Many of the cases have said that. For instance, Commonwealth versus Hardy, the appeals court case suggested that in that case, I believe there was evidence of large amounts, but at the very least there was significant evidence of multiple sales, which in turn supported an inference of a large amount, which in turn suggested that it would be less likely to be stored in a car, or it would have to be stored in the house. And so that in itself, the amount was a factor. That's lacking from this particular affidavit. In addition, much as in Medina, the surveillance that took place with the police reveals nothing whatsoever to add to creating a nexus between this house.
It does, I think, fairly conclusively provide evidence that this person regularly used this house. It was his house, right?
It was his house, yes. And in fact, that is the sole. It concludes that he resided there. In addition, I believe there was some other surveillance, not just sort of watching him, but some of the independent investigation on part of the detective concludes. So yes,
Is there any indication from the confidential informant that the time between the phone call the confidential informant had made in the past to the time that the sale occurred was so brief a period that it would not have left any time for the defendant to stop off any place to pick up drugs?
there is not. I believe that the affidavit states that when he had purchased, that he made a phone call to him, and then he met him at a prearranged location. No, there is not any evidence as to.
I thought the affidavit, though, says that there's a police officer surveilling that and sees him leave the house and go to the prearranged location.
I believe it does, but I don't know that it says.
That's the one controlled by?
Yes.
There is a single control by. There
That the
are no
police
other-
have observed?
That the police have observed. There were no others. And I would suggest that in of itself falls far below anything that this court or the appeals court has allowed as being the floor on that.
The question is whether that, I mean, I agree with you. If that was all that there was, simply this person called this number and got somebody who said, meet me at this place, and we followed, and there was a drug transaction, I agree that certainly is far less than we've ever said is required. But is that gap filled by the expertise of the officer here who says, there is a method of operation that drug dealers are now using, here's what it is, here are the reasons for it, and essentially we've been able to corroborate that method is in play here because of this transaction we conducted with the confidential informant?
Again, I would say not, in that Certainly, there is a place for an expert opinion, or even, past practices on the part of the detective affiant. In this case, there is nothing more, though. And that's fairly clear. I've cited several federal cases in my brief, as well as, again, Commonwealth versus Anthony, where in that case there was significantly more facts in the affidavit to create the nexus. In this case, the so-called expert opinion, really, it's sort of shoring up of a faulty foundation.
It's not shoring up, it's describing, I mean, the drug business changes. As law enforcement techniques change, so does the business. And the business used to be, I think, the common practice was you could identify a place where drugs were being sold because people were constantly showing up every 10 minutes and spending 2 minutes at the door. Pretty obvious evidence of the practice and the business at the time. That having been sort of a technique or a method of operation that doesn't appear to have been as successful because there are lots of ways to detecting it. Mm-hmm. You now have another operation which divorces the supply from the location of the transaction. So why isn't that a legitimate thing for police officers with a lot of experience to say, this is a method of operation, we have a confidential informant, this is how he purchases his drugs, and we now have done a control buy to corroborate that is indeed the way it's operating here?
Well, I would suggest that much as in Medina, there's a great question as to whether there even is a method of operation in this case. You have the informant say, I have bought from this in the past, this is how I have conducted business. But you have one single controlled buy that is insufficient, I would suggest, to corroborate that. I would suggest that there has not been an established method of operation. So the fact that there is a generalized statement from...
excuse me for interrupting. Where the appeals court says and describes what it says as a common method, where the informant called a specified telephone number, the defendant specified a location at which the informant should meet the defendant, and the two would thereafter meet at the location, you say that isn't a method.
It may be a method. It's not been established to be a method in this case. There's insufficient facts that are set forth in the affidavit to establish that there has been a pattern of operation. I would suggest that one controlled buy cannot constitute a pattern. We don't know whether he's sold in the past from this affidavit, but if he has, we don't know the facts here that this.
Excuse me. I'm distinguishing between whether the method included coming from the house. I thought that the affidavit said that there were several prior instances, and in each case, this is what of buys by the confidential informant, and in each case, this is what happened. I telephoned, and then I'll repeat the same three things.
Well, I would suggest that the affidavit does not state how many times that this has happened. As I say, that the affidavit perhaps suggests that this happened at least once.
Well, I take it, I had understood you to say that, well, there may be a method that's involved that uses cell phones, and the drug dealer tells the purchaser to meet him at a certain place. And what we know of the method that is employed is only a part of the method. It's not the whole method. We don't know the entire story because we don't know where the drug dealer is where the sale is actually, or where the procedure is actually originating from. We don't know where he's getting the drugs. We know where the drugs end up, and we know how the sale is activated. But that's as much of the picture as we know, and that's not enough to establish probable cause for the origination point.
Right. That's right, Your Honor. And I would suggest that just getting into Commonwealth versus Luthi, which the appeals court relied on heavily in this case, they did in Luthi, and again in this case, they did rely on the method of operation. And in fact, they state that in Smith, there was no, one of the distinguishing factors was that there was no method of operation in that case.
But in Luthi, weren't there
There
two
were two,
confirmed
yes,
buys?
exactly.
From origination point to terminal, to the
Exactly.
other end, to the
No,
sale
no,
point?
there's only
No,
one that was fully observed.
There was one observed, that's right. But there were two controlled buys, and in fact, the controlled buys corroborated they confirmed the method of operation. And in fact, if one looks at Luthi, they do rely on they cite several times the two controlled buys. But Justice Cordy is correct. One was completely observed. If there were no further questions,
Thank you, Ms. Dougherty. Mr. Gold?
Good morning. May it please the Court, David Gold for the Commonwealth. Your Honors, you've heard from both my sister in the prior case in Medina, so I don't want to repeat what has already been said. But what
I don't notice, there's nothing in the affidavit, is there, about the time frame between the call asking to buy the cocaine and the time when the defendant left the apartment?
Nothing except for what Justice Botsford pointed out, which is that the defendant was followed by another police officer to the buy location. But there is nothing concerning how long it actually took between the time of the phone call and the time of the controlled buy.
Isn't that a major distinction?
A
It
major...
took 3 minutes in the other case, after the phone call for the delivery, right?
Yes.
Here, we don't know.
Here we do not know how long it actually took for the delivery. However, I wouldn't say that that's a significant distinction because the police were, again, following the defendant when he left his apartment and went to the controlled buy location.
And they were in position before the call was made. So in other words, there's no, if he had left the house to go someplace to get the drugs, he would have been observed leaving the house. Is that your point?
That's correct, Your Honor. There were two police officers. One was observing the CI and one was observing the defendant.
Do you think Smith was wrongly decided?
No, Your Honor, but I would highlight that Smith did heavily rely on Commonwealth v. O'Day, although the appeals court decision. I believe O'Day and Smith were both decided in the same year, and this court addressed O'Day and said, of course, affirmed the trial court in O'Day and said that there was a substantial basis to search the defendant's apartment. So I think also Smith can be distinguished from this case because in Smith there was a CI who purchased the drugs during the first controlled buy. But something is important to note on that is that the CI, during that controlled buy, the defendant was not observed leaving his apartment. He had just arrived at the scene and sold to the CI. The subsequent controlled buys were done with an undercover police officer. There was nothing in Smith that described the method of operation, which is a significant difference.
I know that this isn't in the record, but is there any reason why the police can't conduct two controlled buys and witness the defendant at each time going directly from his apartment to the meet location?
There's nothing that would prevent the police from doing that, and I would concede that the police, of course, did not do that in this case.
The question is whether they are required to do that.
No, Your Honor.
That's what I'm saying. If we rule against you, it in essence says you've got to do at least two controlled buys.
And I believe that this court in O'Day addressed the issue which Smith, as the defendant in the defendant's brief, apparently wants Smith to stand for the proposition that only one controlled buy, if there's only one controlled buy, that there's no probable cause. But this court in O'Day did not give Smith that narrow reading and said that one controlled buy without more may not give enough for probable cause. But here, as I've described, there was more. There was the informant who described the method of operation. He would make a phone call to the defendant. The defendant would then deliver the drugs to him away from his apartment. And also there was the police officer who wrote a substantial part of the affidavit about his knowledge of what, how these drug delivery services work and what their purpose is. The purpose of these drug delivery services are to keep the...
It's pretty general. I mean, Does this turn on the sort of general conclusory statements of the police officer? I just didn't, they do seem pretty conclusory. This is the way it's done, period.
Yes, Your Honor. It was general in that his knowledge about how these drug delivery services work was a general statement. However, put in context, this police officer had, I believe it was 8 years of experience, and also it matched what the informant said in this case, which is that the defendant's method of operation was to deliver drugs away from the apartment. So this wasn't read in isolation. It may be considered a general statement, but the reason the police officer included that information in the affidavit is because the CI actually described a situation which was almost identical to how the police officer, which was identical to the situation the police officer discussed.
But did the CI ever say that the defendant is selling the drugs from his apartment? I'm calling him at his apartment?
No, Your Honor. The CI.
So what is there to connect the apartment?
What's there to connect the apartment is the CI did state that he knew that the defendant, he said he believed that the defendant lived in the apartment, and the police verified, as I believe my sister pointed out.
So it's there. It's a truth. It's a universal truth that drug dealers keep their stash in their apartment all the time.
No, Your Honor, I wouldn't. I would disagree. I would say that in these circumstances, though, where the defendant was observed leaving his apartment moments after receiving the telephone call, which he did receive in his apartment, whether it was by cell phone or not, he received the phone call inside his apartment, and he went to the buy location, that those drugs needed to be, there had to be a stash somewhere. And the probability...
There has to be a stash somewhere, but in looking at the affidavit of this very experienced police officer, he says, he's explaining why we're doing this, right? He says, first, they allow the drug distributor to control the time and place of the delivery, making it difficult for police to conduct drug transactions. It seems to me that, at least as to time, in both cases, we don't, the time is when somebody wants to purchase drugs. They may control the place, but I'm not sure about time. And then he says, secondly, they allow the drug distributors to conduct drug transactions away from his or her principal residence where they store narcotics intended for distribution. But that's the issue. I mean, he's saying, I know they store them here, and that's why they do this. Right?
Correct.
There's an assumption that the drugs are stored there.
Correct. And that assumption was based on the...
No, but once you have that assumption, then you say, and because I assume that, this is why they do it this way. But let's assume for a moment that the drugs are not stored at the residence.
Sure.
Right? Then all of the explanations as to why this is a pattern falls away.
Correct, except that I believe the affidavit also needs to be read with the information concerning the actual controlled buy.
If the drugs weren't stored in the apartment, then the scenario that actually happened is impossible, because the seller didn't know he was going to get a call from the buyer, yet he immediately had the drugs to go to the sale. So he had to have the drugs on him, and he didn't know he was going to get a call.
Well, he might
right
have
at
the
that
drugs
minute.
on him.
Well, he had it either on him or in his apartment, because he got a call and then went to the meat place. And he didn't know that someone was going to call him that day to buy drugs.
Correct. The defendant received the phone call.
But where did he get the drugs? Got the
That
drugs from his apartment?
that assumes that if a defendant, if there's a call and the police observe the defendant leaving anywhere, from anywhere, and going directly to the point of sale, they can search that place. Correct? Forget about what the police say this is the way drugs get conducted. If there's a telephone call and the police happen to have the defendant under observation, and he or she goes immediately, they may have one, packet of cocaine or whatever the drug is, and they go immediately and sell it, the inference is that from wherever they were at that time, the police can search that place.
I think the fact, Your Honor, that this is an apartment is an important consideration. Because
It is important because that's what the Constitution protects more than any other space.
Yes, Your Honor. And also the fact that he had total control over that apartment and that it was
That
unlikely.
that doesn't help. It just simply says if the police observe, there's a telephone call, they know that the call was made, and they watch the defendant, and the defendant is at in any place, why does it make any difference?
Because if it were a public place like a movie theater, or a bar, or a restaurant, it's very unlikely that the defendant would be storing his drugs there because it would be subject to being stolen by somebody else. So drugs have to be stored in a secure place, because one of the biggest problems is theft by other drug dealers or whatever, by other people. So if the call came to the defendant in a public place, then there wouldn't be probable cause to search the public place, because it's unlikely that drugs would be stored there.
I don't want to get into a discussion of inferences with my distinguished colleague, but I would suggest that one thing that drug dealers know is that people will assume they have their drugs in their home, and they get broken into on frequent occasions. They may have a friend who has a bar. They may have somebody down the street where they're keeping a small quantity. I mean, it's an inference on an inference on an inference, and that's the problem here.
But, Your Honor, also I would point out the fact that he kept the drugs in his apartment as opposed to somewhere else, the fact that he had total control over that apartment,
I understand the control argument.
and that it would be unlikely that he would keep his drugs in another place where theft could occur, or
He could keep them in a locked, container someplace else. He could keep it with his best friend. I mean, it does. All I'm saying is, if this is sufficient to search that place, it is sufficient to search any place.
I would respectfully disagree with Your Honor that if for example, if the defendant conducted a drug sale while in received the phone call while in, for example, a crowded movie theater.
No, I'm not talking about a crowded movie theater. The defendant is observed constantly hanging out at, Sloppy Joe's bar. I hope there's no such bar called Sloppy Joe's, but at some bar, day in and day out. People come and go, people come and go. It turns out what he has is usually carries, 5, 6, 7, 8, 9, any amount of, you could search the defendant, no question.
Yes, and I would also suggest that it could, in certain circumstances, and I believe O'Day was one of the cases where there could be a source in more than one location because of the nature of drugs. The defendant could have kept drugs both in his house and at the bar, in Your Honor's example, and that the fact that he received the phone call in this case while he was in the house and was able to immediately deliver the drugs to the CI while being observed by the police, that combined with the confidential informant's description of the method of operation provided a sufficient nexus for the police to search the apartment. And if there are no further questions, the Commonwealth would rest on its brief.
Thank you, Mr. Gold.
Thank you.